All right, everyone, we're going to go ahead and get started. Good morning to everybody who is here at the Burke joining us today and everybody joining us via Zoom. My name is Stephanie Macias. I am the Business and Workforce Development Manager here with the Business and Employment Resource Center at the City of Moreno Valley. For everybody joining us on Zoom, we have attendees here in person and vice versa. So if you guys are having any questions, please feel free to throw them in the chat box or any comments, and vice versa here in the classroom if you have any questions or comments. If you could please speak up so our attendees from Zoom can hear. Just to let you guys know a little bit about the Burke, we offer resources to job seekers and small businesses alike. So if you guys know anybody who is currently looking for work, who is looking to upskill, who is looking for some educational opportunities or just resources for the workforce, please send them over to us. We have plenty to offer. We have different office hours with our county partners, our career coaches, representatives from CBU, Cal Baptist University, from UCR, and Moreno Valley College. But on the small business side, we host something called Small Business Wednesdays, which is why we are here today. We bring in different organizations to present on different topics, ranging from how to start a small business to HR tips to QuickBooks, to items like today having to do with legal matters with our wonderful team from ICLS, Inland County's Legal Services. So I'm going to go ahead and turn it over to Matt, and he's going to be doing our presentation today.
Yeah. Hi. Thank you, Stephanie and the Burke, and thank you for being here. And thanks to everyone online. My name is Matt Kugasaki. I'm an attorney here at ICLS. I'm actually going to be talking for just about 5 to 10 minutes, and then we're going to hand it over to our experts who are here. They're attorneys who are experts in doing business online, and they're going to talk about best practices in doing business online, including privacy, running a website, and all the legal things you need to know. But before we hand it over to them, I am going to, let me see, trying to move. Sorry, I'm just having a tech issue. Oh. There we go. Just a tech issue with our slides. Our first slide is very exciting. It's our legal disclaimer. Basically, we just want to let everyone know that the contents of today's presentation is for informational purposes only. We are not, I am an attorney and you're going to be hearing from other attorneys, but we are not your attorneys today or ever. Unless, of course, you'll learn about our services at ICLS and how to apply for our services. So if you are interested in learning more about how some of the concepts today or other legal concepts apply to your businesses or your business, you can apply for our services, and then you will be our attorney. But again, for today's purposes, we are just providing legal information. So Inland County's Legal Services, as I mentioned, I'm an attorney here at ICLS. ICLS is a nonprofit organization. We serve Riverside and San Bernardino counties, including the wonderful place of Moreno Valley, where we're at today. And we provide free legal services in a bunch of different areas. On the gold part of the slide, you can see, I'm not going to go over all of them. We've highlighted today small business and nonprofit. That is the program that we are representing today. Kayla, who is here, and I are both attorneys from that program, and we provide, as suggested, free legal services to nonprofits and small business owners. In this slide, you'll see some of the core areas where we provide services. We help review and draft contracts. We help people understand if they're operating under the correct entity. We meet with a lot of sole proprietors who might be interested in forming an LLC, or folks who formed an LLC that might be interested in forming an S Corp, or maybe they don't need to be an LLC anymore. So we help people through that understanding and that process, and we help people form, if appropriate, form it as a different entity. We also help with other early business formation issues. We also help with intellectual property, that's trademarks, copyrights, patents. We do a bunch of programming, especially around trademarks. If you're operating with a business name or a logo and you want to protect your brand identity, that is something you may want to pursue. Also, employment law. If you are a business that is even thinking of bringing on your first intern, employee, independent contractor, or someone just to help you out, you may want to talk to an employment attorney through our program. There are a lot of laws regulating employment law, both in the state of California and federally. So we help in that area. We also assist with regulatory issues for nonprofits. We also do bylaw reviews, help people prepare for emergencies and disasters, and help with nonprofit governance and other issues as needed. And it's at the bottom, not to mean that it's not important. It's more to show that we recognize that small business owners and nonprofits have a whole bunch of different issues And while some of these are the common issues, there are a lot of issues, including today's presentation about doing business online, that is applicable to most businesses that we serve. We are very excited to offer this program through the attorneys that you're going to hear from very, very soon, I promise, because it is a new program for us, and it's all because of feedback from folks at the Burke, community partners, and people who attend our events that ask a lot of questions about what do I need to do if I'm online? I hear about privacy policies. I hear about website terms of service. I hear about all these things. I hear about marketing online. What are the legal kind of rules related to that? So because of that, we are very thankful to be working with the experts that I'm going to introduce shortly to create this programming for you. Overall, our program helps small business owners and nonprofits in our region, so that is in Moreno Valley, but also extended through Riverside or San Bernardino counties. And we help with transactional legal topics like the ones I said. That's another way of saying we do not assist with litigation. So if your issue is I'm being sued, or I'm in the middle of a lawsuit, or something related to a dispute with another party, we are very unlikely going to be able to assist directly. We may be able to provide referrals. We may be able to do some research to help understand the strength of a lawsuit, but we generally cannot assist with litigation. Another point that I'd like to make is all of our services through this program are delivered through volunteer attorneys that provide their services for free through their law firm's pro bono programs. 2 points related to that. One, we work with experts in the field that are currently practicing in these areas. At ICLS, Kayla and I have some expertise in some of the areas, but you're never going to find an attorney that could advise in every single area. So we take a lot of pride in the fact that we're able to work with such accomplished, amazing attorneys who are doing the work in these areas, but also are providing their services for free through their law firm's pro bono programs. The caveat with that comes 2 things. One, we can't guarantee services. We do kind of operate as a matchmaking service, so we try to find attorneys, but since they're not on our staff, we can't just deploy them as we would if they're on our staff. But we do have a lot of success in matching people with the projects that they need. And 2, a lot of our services end up being virtual because we try to recruit attorneys from around the state and even around the country in some circumstances when it's related to a federal issue. So a lot of the services are virtual, but if you need in-person, if there's something about signing things or other needs for in-person experiences, we will have you join our office and we can bring in some of our volunteers virtually. Finally, my last slide, I just want to highlight 2 programs that are coming up. We have an entity selection clinic in April where we are helping people, like I mentioned, we help people understand if they're operating under a correct entity. Our attorneys will go over the pros and cons, the different entity types like LLCs, S Corps, C Corps, operating as a sole proprietor, give guidance on partnerships and other just kind of like early business formation issues. It's a wonderful clinic. It also serves as kind of a issue spotting clinic in that you'll meet with attorneys who are skilled in this topic, but also are trying to help understand if you have other legal topics. So if you're at a stage of your business or if you just have general questions about how you're operating, this would be a great opportunity for you. Spots are limited, so I encourage you to sign up. The top part, though, which I saved the best for last, as relevant today, we are launching our first ever Doing Business Online clinic, where we're going to have expert attorneys similar to today. However, it'll be without the caveat that it's only legal information. We are setting up individualized, virtual, free meetings with attorneys who will talk about how to do business online as applied to your business itself. We again have limited spots for this. They will take place in April at a time that works for you. And if you're interested, the first step is to fill out our online form, which I will also put into the chat for you here. If you want to scan the QR code, feel free to do that on the screen, but I will put that in the chat as well. I will say we love active attention, so we don't want people, I don't want to encourage being distracted, but if while you're listening, you also want to start filling out that form and bringing it up to apply for services, that is one thing we love when people do that. We love seeing the forms coming in during or shortly after the webinar. On that note, just a housekeeping thing, you will get a copy of this PowerPoint shortly after this webinar, either today or tomorrow, which will also include the links to apply for our services. Again, we encourage you to apply for these services. These are our two programs that are upcoming. There is limited space, and they'll come kind of first come, first serve. So we do encourage you to apply. But if you have issues outside of these two kind of topics, we also encourage you to apply because we are always trying to connect people even outside of our regular webinar schedule. All right, with that, I do want to introduce, well, first I'm going to take a pause and see if anyone has questions just about ICLS, our services, and our upcoming programs. Let me check the chat. I don't see anything. So with that, I'm very excited to introduce Alina Wattenberg and Leon Freiermuth, who are attorneys at Gibson Dunn, which if anyone hasn't heard of Gibson Dunn, it is one of the premier law firms in the world. And they have probably hundreds of attorneys in California, many of whom are corporate attorneys, some of whom, including Alina and Leon, are experts in doing business online. And they can talk much more about their practice and they're going to provide the legal information at the core of today's presentation. But I will say that they help businesses day in, day out with similar issues. And they may be available or not, but if you do apply for our services, we work with people like Alina and Leon, who then deliver the legal services through our clinics and other programming. With that, I don't know who's going to speak first. I see, Alina, that you are on camera, so I assume it's you. So I'm going to hand it off to you, Alina. Thank you, and Leon, both so much for being here.
Thank you. Thank you for the intro. Hi, everyone. We're very excited to be here. So as has been said, the goal of today's presentation is to walk through some key legal considerations for doing business online. We will go through things like terms of service, privacy policies, marketing strategies, risks associated with intellectual property. And what you'll hear us continue to iterate throughout this presentation, which was also alluded to earlier, is every business is different. There's no one size fits all, and you know your business the best. So there will be different legal issues we talk about that may apply to you or may not. And our goal with this presentation is to give you a very high level framework to help you identify the areas that are most relevant to your business, how you can avoid common mistakes, and what sort of best practices you can implement. I'll be presenting with Leon. We're both attorneys at Gibson Dunn. We specialize in privacy and we do a lot of counseling for businesses like yourselves who are trying to understand how to comply with an increasingly complex network and web and patchwork of regulations. I think we can turn to the next slide. Great. So the first section of our presentation will talk about terms of service and privacy policy. So as a quick overview, you can think of your terms of service and privacy policy as agreements between you and the people who visit your website or use your app. They are in everyone's interest, though they might not be legally required in all cases because they set expectations at the outset on what you're providing and what people who use your services are agreeing to. Again, there's no perfect privacy policy that applies to all cases, or terms of service or privacy policy that applies to all cases. So we recommend customizing these, making them super clear, and working with an attorney to ensure it's tailored to the services and products that you provide. With that, I'll turn it over to Leon, who will talk more specifically about what we recommend you include in terms of service in a more detailed level. I think we can turn to the next slide. Thank you.
Yes. So terms of service. So we can go ahead to perfect. You've probably seen these yourselves if you've ever been on a website. They're sometimes called terms of use or user agreement or terms and conditions. And these are all just basically different terms for the same kind of document. When they're done correctly, they're a legally enforceable contract between you and the visitors to your website or the people who use your services or the people who are buying stuff from your website. They will bind the users, but they also bind you. So it's particularly important not to just copy and paste these kinds of things from some other website that you find online and say, I don't know, this looks right, because you are creating a contract, and it might not say what you want it to say, or it might say something that you really didn't actually want to agree to. So it's really important that you understand whatever terms and policies you are putting out there, including because typically, if you wrote it or you put it on your website and the customer just visited, it's interpreted against you in favor of the customer, in favor of the person who didn't write the agreement. Um, as Alina mentioned, any website is really best served by some terms because stuff happens. There's disputes, there's disagreements, whatever it is, and it's good to set up how those sorts of things, what the expectations are, how those sorts of things will be handled in advance. So regardless of whether they're specifically required or not, it really is recommended to have them. And we can move to the next slide. So then what should TOS do? Terms of service should set the user's expectations about your website, how it should be used, what kind of services you're providing, what kind of services you're also not providing. Maybe you're providing a very specific thing and somebody's using it in a way that was never intended, and then that goes wrong and they get upset at you. So you want to be clear about what it is you're providing and how. Behavior for how a user should use your website. For example, if you allow users to post comments on your website or whatever else, or to interact with each other. Important to set rules for how they're supposed to behave when they're doing that. As I mentioned, resolving disputes is always a good thing to set the rules for in advance and not, once you're already fighting with somebody. And then also, you want to limit your potential legal liability because, I told you not to use my product in that way. You knew you weren't supposed to use my product in that way. You don't get to now come after me because you did it anyway. That kind of thing. We can go to the next slide. So for dispute resolution procedures, which is legal term basically for where you can be sued, if you are sued, which laws apply. If you're doing business in California and you've spent time to familiarize yourself with the laws in California for your particular business or service, you want to maybe be clear that California law should apply to any lawsuits or disputes and not the law of Tennessee or whatever, which you don't know anything about and have never heard of and don't want to be responsible for. And then also whether you want to go to arbitration versus trial. Arbitration is basically a sort of private trial system, I think. You can think of it that way. And it's easy to say, well, this will never, I don't have to worry about this. How likely am I going to get sued? And unfortunately, I think the longer you do business, the more people you do business with, the more successful your business is, especially the more likely it is that you will be sued. So it's just good to be prepared. Limitations of liability, talked about a little bit already, but direct sales, this is where it's often especially important if you're selling a specific product online and some people want to return them. They want refunds, they want to cancel, they want to change their delivery preferences, whatever it is. Your terms should set up in advance, when will you offer refunds? When will you offer returns? How long? All this kind of stuff. You've probably dealt with yourselves also when returning things. And you just want to be really explicit about what the rules are in advance and think about also what kind of rules. It's also an opportunity to think about what kind of rules you would like. Like what do you want to offer your customers? What is too much for you to offer? These are also can be complicated. So this is especially, I think, an area where we would recommend that you seek additional counseling, legal counseling about, what kind of rules might be in place there and what kind of rules you might want to set just because it can get complicated. And especially if you're processing customer payment information, but I think we'll talk about that a little bit more later on. Lena, you came off mute.
Oh, sorry, no, go ahead.
Okay. Then a few other things, intellectual property elements. If you have a logo for your website or a slogan, or maybe you have, I don't know, some pictures you took, or you're selling art or whatever it is, all these kinds of things, right? It's about intellectual property, about the rights you have, about ideas and creative works that you create. And so handling that in your terms of service is one thing you want to do, and we'll talk more about IP generally later on. if you depending on how much and what kind of information you're collecting, if people can create accounts or can fill out a contact form to get in touch with you, you might want to handle, how that information is handled and what you do with it. And the terms of service is part of that there, but then also very importantly, the privacy policy, which Alina will talk about more. And then for international issues in particular, things can get a lot more complicated and there's a lot more variability. So if you're doing anything international, you may also need special advice. And we can, right. So just in general, keep in mind like age requirements. Are you selling to minors or not? How does your terms of service interact with others? If you have an app in the App Store, the Apple App Store or the Google Play Store both have their own sets of terms. How do those interact with yours? If you're selling stuff on Shopify, Shopify has its own terms. How do those interact with yours? Do you want to prohibit certain things entirely? How does IP ownership work? All this kind of stuff. All this kind of stuff are things you'd want to think about. Great. We can go on to the next slide.
Great. Okay, so you could spend all this time putting together a very detailed, thoughtful terms of service. But your terms of service is only as good if the people that you are doing business with see them and have consented to them. If someone can argue that they never consented to a terms of service that you developed, they may not actually be bound by the things that you've included. So we can go to the next slide, but what does user consent? How do you do that? How do you make sure that you are actually getting consent from people to comply with your terms of service? So there is a spectrum of methods to do this. On the one hand, there are methods that are easier to implement, but maybe don't have that clear moment where someone clicked agree and saw your terms of service and said, I agree. And then there are, some methods that require more legwork, are harder to implement, but don't have that same sort of, and do have a more of a clear point of agreement. Which type of method you use depends on the business, the types of risks that apply to your business, riskier business, businesses that have to comply with that collect more sensitive information or have to comply with more heightened privacy obligations may consider implementing one of the harder methods of consent. But as an example of a easier method of consent, which we see often like a link out to the terms of service, very clear on a website, and then the terms of service itself will say, by using this website, you agree to these terms. A harder, method of consent would be a user is pushed through a flow. They have to create an account. In order to create an account, they have to click agree to your terms of service, and then they're able to access your products, your service. So those are just a few examples and things to consider. And we can turn to the next slide. Modification. So businesses change, your terms of service should mirror those changes. So it makes sense that your terms of service will evolve. What's critical, and this sort of goes back to this idea of consent, is that when you make these really meaningful changes to your terms of service, you're notifying people about them. So a significant change that would require kind of heightened notice would be, for example, changes to the types of data you're collecting, how you're handling that user data, how you're deciding to resolve disputes. You might want to we suggest you notify your users about that. And that can be done by a very visible banner or by directly emailing users about this change. More minor updates don't require that same level of notice. But it's good to keep a record of changes, but also, in your terms of service, you can add at the top. We see this often, like updated and then date. And that can also kind of serve as like a lower level type of notice. Turn to the next slide. Thank you. Okay, so now just turning to kind of more special, discrete considerations that may or may not apply to your business. So some businesses sell products or services directly through their website. If you do that, this might be an area to get more tailored legal advice on because that often means you're collecting and processing payment information. That is a more that is a more sensitive category of data. And so it can mean you are subject to other laws that are, specific to payment processing. So that's one flag for direct sales. Another flag is, and Leon already mentioned this earlier, but we recommend thinking carefully about your policies with respect to sales and including that in your terms. So like, what will the actual transaction look like when somebody's bought something? What does a refund look like? What does a return look like? What does a cancellation look like? So it's clear from the outset what you're agreeing to, what the person is agreeing to avoid any misunderstandings. And we can move to the next slide. Thank you. Okay, now another special consideration, again, may not be applicable to your business, but just flagging as kind of a key risk area that we see for many businesses is user-generated content. So if your website lets users upload or share content, like they're adding reviews or photos or comments, or they're drafting a story and providing it on your website, that can introduce risk. So we recommend, again, this would be an area to include in your terms of service, thinking about what is allowed and what is not allowed when users are uploading and sharing this content on your website. So this would mean like content moderation. What are your rules and standards around what is allowed, what is not allowed? Also, setting expectations around not sharing personal information, like sensitive personal information on your site. Again, this is a area we're flagging to consider, and we recommend getting more tailored legal advice depending on whether this is something that's relevant to you. I think I can turn it to Leon now. Thank you.
Yes, so I think we mentioned in the beginning there are like two main parts to this. One is the terms of service. The other sort of part is a privacy policy. Privacy policy is it's a public-facing document that describes how you collect and use and share and what you do with information that you collect from or about people who visit your website or use your products or services. When it's written correctly, the idea is to give people notice, basically, make it so that they can't claim that they weren't warned or that they weren't told. What information is collected, how you're collecting it. Is it just through somebody inputting information into a form, or by automatically visiting the website, you might connect some visitor information about them so you can track, for example, how many visitors you have to a website, right? How you're using that information, how you're disclosing it to others, basically. Whom else are you sharing that information with? For what purposes, why, and how? Whether you're selling it to third parties, that sort of thing. Then also, depending on your state and your business and what you're doing, users might have legal rights that they can exercise regarding the information they share with you. And even if you aren't legally required to offer them those rights, you might still choose to do so voluntarily, for example, to offer somebody the right to correct the address information that you have up for them, for instance, or or their contact information for how you can reach out to them, that sort of thing. And again, there's a sort of limitation of liability aspect here where, you're being clear about what you're doing and what it is you're not doing, and that helps limit your potential legal liability. It's especially important if your website is directed at children. So if you are selling tobacco products, for example, that is not generally a service that is directed at children. But if you are selling toys, that is, in some sense, something that is directed at children, even if you are maybe mainly intending for the parents to purchase them. The fact that you're selling toys might indicate that you are directing your website at children, and so you should take into account, what sort of information you might be collecting from or about children if you're collecting it from the parents. And then also describing generally your data security practices and, what sort of security measures you're taking, if any, and whether those, that those security measures might not be perfect, that sort of thing. Yeah. So as I mentioned, many states do have laws that require all websites to maintain a written privacy policy. But even if that isn't your state in particular, or if the laws in your state don't apply to your type of business or whatever else, it's still very much recommended that you sort of set the groundwork there, set the expectations so that by taking the first step and doing that, you have a lot more control than if you just stay silent. I think I mentioned this with regard to the terms of service already, but it's true for the privacy policy as well. And I think it bears repeating, is that you can very much be held liable for what your privacy policy and terms of service say, and especially if they say that you are doing something and you're not actually doing that, which is why it's once again really important not to just copy and paste terms of service or privacy policies from other websites onto your website. Because if they say that they're doing a bunch of stuff to protect the user's information and you're not doing all of those things, then the fact that you said that you would be and you aren't becomes a real risk for you. Go to the next slide. So I think it's helpful also maybe to talk a little bit about what personal information is. I think we often, when we think of personal information, we think it's just, someone's name, the address, maybe their phone number, maybe their email address, but it's actually much broader than that. It's any information at all that relates to or can be associated with a person. So anything, any piece of information, any data that can be tied back to a person or to a person's IP address is personal information. Some types of personal information are riskier than others, of course. Even something like a name in combination with a date of birth can be more sensitive because I'm sure if you've gone to a doctor's office or whatever, they'll often use your date of birth to check whether you are this person, this patient, whatever else. But also sexual orientation, someone's employment status, someone's marital status, their religion, biometric information, all of those things are especially sensitive and can be entitled to special protections. We move on. So some common ways that lots of websites use information is just to communicate with your users or your customers and clients, potential customers and clients. Or to allow people to open an account on your website, or to reach out to you so that they can purchase services or products from you. So that you can run analytics on your website, for example, to see how many visitors you're getting, or if how many of those visitors are interested in product or service A versus product or service B. And then also if you might advertise on Instagram or whatever, and in which case you might share some information about visitors from your website with Instagram so that you can target ads at other people who are similar to the people who are already visiting your website. We can move to the next slide, please. So all of these are things you'd want to address in your privacy policy. Just to give a little bit of a recap is, what information are you collecting and how? And that's not just name and address, that's everything you're collecting from or about a person, how you're going to be using it, whether you will use it for marketing purposes, either for emails or for targeted advertising on Instagram. If you sell your business to somebody else, will that information be, go along with your business to the new owners? outside of that, are you maybe sharing it with other people who are going to help you provide your services because you need, you subcontract some things or whatever else. That's the kind of thing you want to cover. Any rights available to your users, how you would limit liability. And then, as Alina mentioned, with regards to the terms of service, again, if you make changes to your privacy policy, how would that be addressed? How would you share those changes? And then again, if you're doing business internationally, you might want to consider getting more specialized counseling since things can get a lot more complicated. And with that, I think I'll hand it back over to Alina and we can go to the next slide.
Yeah, so we'll now dive into some special considerations. Leon already mentioned a few of them, but we'll just dig a little bit deeper. So first, privacy laws. So there are geographic considerations. If you do business in a particular state or you do business with residents in a specific state or country, additional geographic specific laws may apply to you. Again, we're navigating a patchwork of federal laws, state level privacy laws, and then international laws. So for example, some of you may be familiar with the California privacy law, but if you collect personal information from California residents and you meet certain thresholds, which are actually pretty significant thresholds, we've listed them here, the CCPA applies, and we recommend speaking to more California-specific legal counsel. There are also other state laws, and you may not be subject to these laws, depending on where you do business and also the size of your business. That can come into play as whether they apply to you. So, for example, businesses are generally exempt from privacy laws in Texas and Nebraska if you have fewer than 500 employees. That said, there are more nuances, like if you collect sensitive personal information like biometrics, information on health, on race, you need to provide users with an opportunity to provide opt-in consent to collecting that data. But just flagging that there are geographic considerations and different laws may have different requirements, and they may not apply to you even if you do business in those states, depending on the nature of your business, how big it is, or how much information you collect from residents of that state. Similarly, looking outside of the US, if you do business internationally, particularly in the EU or UK, there are data protection laws like GDPR that may apply, and we likewise, recommend seeking more specialized regional counsel if that might be a consideration for your business. We can move to the next slide. Thank you. Okay, so another area of we see heightened risk for businesses is if a business collects or uses healthcare related information. So information about the health of the people that use their services or products. And in some cases that can be defined pretty broadly. So not just like clear medical information, but like a mental health illness. So if that could potentially apply to you, there are laws that regulate the collection and use of sensitive data, of healthcare data. And for example, HIPAA is one that many people often hear about. Another kind of risk flag is when you are, and Leon mentioned this earlier as well, when you are directing your website or your services or your products to people who are children under the age of 13, or that you're collecting information about children, and this is actual knowledge, like you actually know that you're collecting information about children who are under 13, you may be subject to COPPA or to more significant requirements under state privacy laws because there's a focus on having more protective practices with respect to children. As far as like practical tips for complying with these regulations, if you do not intend to target children under the age of 13, we recommend noting that in your terms of use and privacy policy. And this sort of underscores what Leon and I are continue to mention, which is the terms of service and privacy policy should be unique to your practice and can be really important protection for you on what you are actually providing and intending to provide. Also, separately, if you do collect age information, best practice under these laws that we would recommend is displaying a link to the privacy policy to provide parents with notice, obtaining parental consent prior to collecting personal information about children, and providing a very clear opportunity for parents to review or correct any information that you are collecting from children. Can move to the next slide. Okay, so now turning to marketing regulations. Online targeted advertising. So targeted advertising means that you are showing ads to a specific group of people based off of information you have on their interests, their behavior, or their demographics. So it's basically a more targeted way to advertise because you're advertising to people who, based on information you have, may be most interested in your products or services. Oftentimes, businesses get this information by using website cookies, which many of you may be already familiar with. We get these pop-ups on the websites that we go to that say related to website cookies. There are various state privacy laws around how data can be used for targeted advertising. So these may apply to you depending on your business and the size of your business. But again, a common theme, best practice is to take a look at how you're advertising, how you're using information to advertise, and describe those practices in your privacy policy. Next slide. So there are laws that regulate how just on the topic of advertising, you may advertise and communicate with your customers in various ways, emails, calls, texts, and there are different laws that apply depending on how you're communicating. Again, best practice, include that information in your privacy policy that you are using. If this is true, you're using information collected from a website, from cookies for marketing communications, which may include adding someone to your mass email list to distribute information about, events or products or new services. Next slide, thank you. Looking specifically at CAN-SPAM Act, this is a federal law that relates to marketing communications, specifically emails. Any commercial email that you send is covered by CAN-SPAM Act. So it's not just traditional marketing emails and advertisements. It's also as I mentioned, announcements, newsletters. And so this law carries fines if violated. So to address potential violations, we recommend all unsolicited emails should be labeled so it is clear it is coming from your business and has a marketing and commercial purpose. And also, which folks on this call might be familiar with, at the very bottom or somewhere in this email, give users a clear and easy way to opt out of future communications. So a link out, there are third parties that can help do that, help you provide that opt-out opportunity. But those are the core requirements to comply. Move to the next slide. So kind of reiterating what I said as far as practical tips for marketing emails, consistent with a general theme, you should, a key theme here is you should use information that you collect from people in the way that they agreed you could use it. So if somebody gives you their email, it should be clear that they're giving you that email for these marketing communications, and you use that email for only marketing communications. Also, again, easy and clear opt-out links in your emails and a clear label that this is a promotional email. There's no hard and fast rule on what that label should look like, but it should be reasonable to, and just make clear that this is intended for marketing or commercial purposes and is tied to your business. Next slide, please. I think I turn it over to Leon here. Yeah.
So just to give a bit of a background on intellectual property related issues, this is obviously its own enormous field of law with a lot of complicated issues and things, but we thought it'd be helpful to give you a quick overview of some common different types of intellectual property and different intellectual property rights and when and how you might need to think about those. So if we go to the next slide. So intellectual property, IP in general, refers to the legal rights that creators or business owners can have over their ideas and over expressions of those ideas, meaning you might have an idea for a story, writing a story on paper is the expression of that idea. In general, IP includes trademarks, which is specifically for brand names or logos or slogans and that sort of thing. That might, it's how customers, pick a random one. Chipotle owns the Chipotle trademark. And if you started a business and also named it Chipotle and you also sold burritos, that would be a problem because consumers might be confused about which Chipotle this is, whom it belongs to, who is running it, what's going on there. Copyright is, ownership over creative works like stories or paintings or drawings, things like that. And then patents are about ownerships of a novel idea or an invention that does a specific thing. So the sort of the flip side of you having legal rights over your intellectual property is that other people also have legal rights over their intellectual property, which means generally that you cannot use the IP of others without permission, right? Without their authorization. That means, just because you find a picture online does not mean that it's free for you to use. It depends on the terms, the license that the creator of that image has posted the image under. Same time, when you're selecting a name for your business, you should try to avoid a name that infringes on the property rights of others. You can check your state, California, the California Secretary of State website actually has a database of business names, and then the U.S. Patent and Trademark Office also has a database on their website that you can just search yourselves. It is also, we would also often recommend, you can work with an attorney to do more sort of comprehensive searches of trademarks and related words and phrases that you might not think of right away, but that are closely enough related that they could cause issues. And that can be a sort of more exhaustive thing to do. And if we move to the next slide, please. So for your intellectual property, you would want to think of it as an asset of your business, like the equipment you buy, for example. If you start a very successful bakery, the bread kneading machine and the ovens are assets of your business, but so is the name of your bakery. People come to know and love it, and they know that it stands for quality and all those sorts of things. That's an asset of your business as well, and you could license that name later on, or if somebody purchases your business, part of the reason they might do so is because of the goodwill and the good feelings that customers have related to the name of your business. Depending on the type of intellectual property, there's different ways to protect it. In general, caveat especially for patents, but registration is one way to protect your intellectual property. It's not always required. For copyright or trademark, for example, you can have a copyright in a work without registering with the Copyright Office, but you cannot, which means basically that you do own it, but you cannot enforce your rights over that work unless you register it. So registration is a good idea. It's not necessarily always required, but it is often a good idea, though I think there are minor registration fees and things. You can also use certain symbols. You've probably seen the copyright symbol or the trademark symbol before all over the place to indicate that you consider this work or this name your intellectual property. And you can use those specific marks even without federally registering. And if we go to the next slide, please. So for trademarks in particular, it's presumably all of you have businesses that have a name of some kind so that people can find it. Trademark can protect the use of a word or phrase or color or image, any sort of unique symbol that identifies your business. It has to be unique, as I mentioned, and you have to actually be using it. So if you perform a search on the Patent and Trademark Office website, you might see that there are a bunch of trademarks that have sort of fallen out of use, and so protection has lapsed. So that basically means you cannot just hold trademarks, protect trademarks over names and phrases and things that you aren't actually using. You have to actually be using them. You have rights federally and locally if you own a trademark. And as I said before, registration of the mark isn't required, but as soon as you want to enforce it because you want to make somebody else is stealing the name of your business and you want to stop them, in order to enforce your rights, in order to sue them over that, basically, you need to have registered the trademark. And then you can also, instead of using the TM symbol, you can use that R in a circle symbol, which means that the trademark is registered. And that's what the difference between those two symbols means. Duration is in 10-year periods, virtually unlimited, so long as you keep meeting the legal requirements for maintaining and using and renewing the trademark as needed. And the cost of registration is between $250 and $350, depending on the type of mark, the number of marks, and so on. And you can find out more also at the U.S. Patent and Trademark Office. Has FAQs and things, and they have a website and a bunch of guidance on that can also be really helpful. You can move to the next slide, please. Copyright is, like I said, ownership over works, fixed and intangible medium of expression that basically is the difference between like thinking of a story in your head and actually writing it down. Registration works very similarly to trademarks, where you don't have to register it or have the copyright, but you do in order to enforce it. You have exclusive rights about publicly displaying your work, or making or distributing copies of it, or creating certain adaptations within limits of the First Amendment, and so on. In general, it's the duration is the life of the author plus 70 years, or for work created for companies, 120 years after creation or 95 years after publication. In general, I mentioned this before, you should only display content that you or your employees have the rights over, meaning that you have either originally created it or you have specific written permission from the person who did create it to use it. The cost of registration is also between $45 and $200 per work, depending. And that's sort of a general overview of intellectual property stuff. And I think we've done a lot of talking now, so it's maybe a good time to move on to questions.
Thank you so much. We actually have a couple questions in the chat that I've been monitoring, and I will ask now. Real quick, though, I did want to highlight that I put our application form into the chat. So if you are interested, I know there's a lot of information today and about privacy policies, terms of service, doing online marketing, and then also about some of these other issues about trademark, copyright that impact online business owners when you're doing business online. So if you do want more individualized guidance as you're thinking about your questions, please apply for our services. But we do have two, I think, good questions. And I apologize if I paraphrase this a little, but I'm going to start with the first one if I can find it again. The first question about for doing business online relates to where you're liable, what laws apply. There's a business owner in the chat who is based in California, but because of how the internet works, they can do business across the country, in Texas, in Ohio. They may have clients, and even internationally. So I guess the question generally is, and I get this may be more complex and might be someone who might benefit from our clinic, or if you have similar questions, but the question is, what laws apply if you're based in California but doing business kind of everywhere?
Yeah, it's a great question. And I think that is a question that a lot of businesses ask, because I know, throughout the presentation I mentioned there is now that we have online, just because you are based in California does not mean you are only subject to California laws. Laws can apply to you if you are collecting information, providing your services to people who live in other states or in other countries. And there are a lot of overlapping requirements across states, but there are some differences. Um, and a lot of the times, the different state laws will apply or not apply because, for example, your business doesn't meet a certain threshold of like you don't collect X amount of information from people in that state, or you don't have X amount of employees in your business. So it requires a more detailed assessment, but it's the right question to be asking because I think a lot of business owners think that because they're based in one state, they only have to care about that state's laws. And unfortunately, that's not always the case. But it's more nuanced because each state has its own requirements, and each state, it may be that even though you do business with people in other states, you don't necessarily have to comply with that law because you don't meet requirements. It doesn't apply to you. Leon, do you have anything more practical or helpful on that point or anything to add?
Yeah, I think the answer is unfortunately it depends to some degree.
Yeah.
I think you mentioned for the terms of service, you can, say in the terms of service that, California's laws apply to your services because that's where you're based and where you're providing them. And that can be helpful for a lot of things, but there will often be specific laws in other states or other countries that say, you know what, we don't allow that. If you're choosing to do business with our citizens, with people in our state, then you have to do it by our rules. And that sort of really depends on the kind of service, the legal regime at issue, and how conflict of laws work. And the answer is unfortunately very much, I think it depends, but it is, if you want to try to protect yourself, you can put in your terms of service that, insofar as permissible, insofar as allowed by the jurisdiction of the customer, California, this agreement, these services should be governed by California law. And that can be at least partially helpful, even though not always and not in all cases.
Yeah, and also I think like what we've tried to iterate throughout the presentation is there's best practices that are protective across geographic, like wherever you're based, whatever laws apply to you. For example, for the privacy policy, like being clear in terms of service, being clear on what you're providing, what you expect, the guardrails around how your, services can be used. Those are all very like proactive measures you can take to protect yourself across jurisdictions. And so, we've tried to provide some high level principles that will help. And then there are specific requirements in other states, particularly if you're doing some of the more sensitive collection that we flagged, like directed to targeting, children who are under 13 or collecting more sensitive information like payment information, health information, then, that in particular is an area where other state laws or other, specific state laws will come into play. But I think as a general point, a lot of these principles will apply across jurisdictions.
Great. Thank you. We have another good, I think, really good question. I think I'll ask it. And there's a couple questions in here. One is, it's a business that does services only, and their website really is for informational purposes. They have like a contact me that will collect names and email addresses, but otherwise it's for just kind of general purposes. They don't collect a lot of data. However, they're hosted by Wix or Google that might collect data. And I guess the question is, how would a privacy policy apply kind of and I think this is a common circumstance where you don't really collect a lot. Do you still need a privacy policy? And then also embedded is, what if like the host site that you work with or Etsy or someone else that you're operating your business under collects data? Are you kind of liable for what they're doing?
Happy to take the first part of this since Alina took the first part of the other one, and then Alina, whatever you want to add. So the general principle here is that whether it's Wix or Google Analytics or whomever else, it's your website. The consumer is interacting with your website and your business, and whatever information Google Analytics or Wix are collecting, they're generally doing so at your direction. You could turn off the Google Analytics feature if you wanted to, is sort of the theory. And so you're generally responsible still for what data is being collected on your website. Um, to your privacy policy question, as we said, it's not to say if you're not doing very much, that's not to say the policy has to be overly long or overly complicated or, doesn't need to be 30 pages. But it's always good still to say exactly what it is you're collecting, how you're collecting it, what you're using it for, whom it's being shared with and how and for what purposes. So you might mention Google Analytics just as a for instance, right? In that privacy policy, so that you're being transparent and so that visitors to your website, if they're interested, they can, or if they, when they go to your contact form, for example, there might be a link. It's a good practice to put a link, direct link to your privacy policy in the contact form so that people, when they're entering in the information, if they're curious about what you're going to do with it or how it's going to be used, they can just click that link and then they can see what you're doing and they're not surprised by what it is that's happening. Alina, I don't know if you have anything else.
Yeah, no, I was just gonna, that's it. I totally agree. And it's just, I think it underscores the point of like, it's very important to know how you are interacting with third parties and sharing information with third parties. And so this is an opportunity to take a look back at what you've agreed to or what data you're sharing out, and ensuring that it is actually that you need to collect that information, you need to share that information, and ensure that if it's true that you do, you're providing, the right level of transparency in your privacy policy. But to Leon's point, it could, some, depending on your business or your service, some privacy policies will be extremely extensive and detailed and long, and some won't. And it's totally, tailored to what you do. And so if it's true that you're not collecting a lot of information, the way you use information is extremely limited, just noting that in your policy is the right next step and is appropriate.
Thank you.
I have a question.
Oh, great. We have a question in person too. I just want to real quick uplift. Dean, thank you for that comment. I think that really does capture it. Draft a privacy policy, even if it's simple, even if it's mainly for transparency purposes. That's great. But yeah, we have a question here. Why don't you ask it? Maybe speak loud and then
Yes.
I can.
Okay, I have a question. When someone is online, buying something, there is a long list of disclaimers.
Yes.
Pages and pages and pages, and scroll down and more and more and more and more and more and more. That is sometimes it's written in a legal jargon that I guess from an attorney point of view, you're trying to protect every little potential thing that could arise. Just like in real estate, it used to be one page, date, address, price, and boom. Now it's like a 30 pages, 40 pages or more. So what choice do the consumer have at the time, you sign in this thing, I agree, click, 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 click. There is no time to read everything. That you just kind of going through the thing and say, otherwise I can't go to the end and,
Yeah.
So in a litigation case, right, I find out that you sign without reading primarily, obviously. How is the decision made, let's say in a court case? That the judge said, well, you were given the opportunity, it was your fault, you didn't read everything, you're supposed to. So I guess that's my question. Do we supposed to kind of read every little statement? What does it mean? And sometimes you don't have no one, an attorney to kind of, what is this thing to say, so.
Yeah, I think, I don't know if you could hear the question, but I think it is a really good question when creating privacy policies and then also from the user perspective. A lot of times privacy policies that we see as a user on websites or for businesses creating them, there's a kind of an idea that it needs to be long and complicated and has all this legal words and it's not really accessible to the user. Right. So what happens there if there's a challenge to the privacy policy and the user just click, 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 but it's not clear that they even read it or even understood it, or maybe everything's in English, but you're actually targeting folks who don't speak English. Like, what happens in these circumstances? I guess the enforceability of privacy policies that may be more complex. I think that is a very good question. I have a couple thoughts, but I do want to let it go to the panel as well.
Yeah, I mean, first initial thought is many of the, privacy laws, they actually require that the terms that you include be like accessible to your audience and are not we often see like complaints around it's deceptive because it's super unclear or it doesn't say what it's supposed to say or it's really important terms are hidden. So I think this goes to a sort of general guiding point, which is privacy policies should be drafted and terms of service should be drafted so that they are reasonably clear to someone who is not a lawyer or doesn't have a background in these sort of things. And so I think, the best privacy policies are ones that are really tailored and customized and, take into account all the key factors we'd flagged throughout the presentation, but they're also the ones that are clear and concise and don't have a bunch of like what we call legalese, where it's just these words that no one outside of a lawyer would, understand. Obviously, there to the extent there will be some words like that, but I think a principle to keep in mind is that these should be clear and accessible to the audience, which is people who are not lawyers necessarily. Leon, do you have other thoughts?
No, I mean I agree with that. There has been in general a big push to try to make these sorts of documents more accessible, right? Just writing them in plainer language. That said, there's a certain amount of length that can come up. Like I said, depending on how much data you're collecting and how complicated it is, privacy policies can be relatively short. Terms of service sometimes as well, but of course, as soon as you're selling goods and there's refunds and cancellations and warranties and all this stuff is like, well, what if it's been 30 days? What if it's been less than 30 days? What if it's been more? What if the product is defective? How defective does the product have to be before you accept a refund or a return of the product? Do you accept if somebody returns the product, do you give them their money back or do you just give them store credit or whatever else? And so these things do necessarily just often end up being longer because you have to cover all the different eventualities so that you've established the rules in advance, which I think goes a little bit to the earlier point that it is best often to try to establish these things in advance and not have an argument about them once something has already gone wrong.
Yeah, I think that makes a lot of sense. And like one of the things with privacy policies in any contract, and I think Lena, you both mentioned this, but from the user perspective, which you brought up too, is you want it to be clear. You want what someone is reading on your website to be like their interpretation of it is what you expect it to be. You want it to meet of the minds, like when you're banking contracts. Because if it's written in a way where they have a different understanding of what they're agreeing to in a lawsuit, that's going to be a dispute and that's going to be a challenge. So as a business owner, you want it to be clear. You want to highlight the key things. You want it to be in plain language. Of course, there's some language that may need to be there, but that is important to think about when you're creating these policies. And when you're a user accepting them or whatever, you want to understand what you're doing. You do want to take the time because you will be expected if you're signing off on things that you read it. However, you may have an argument later that this was too dense or like not or confusing or other things that were mentioned, but
I guess it speaks of the times that we're living of that, there's a lot of litigation things happening for every, so, and I guess, you have to get the user for an attorney to be on your side, kind of, hey, let me run it by my attorney, kind of see if he can see if it's good. And I guess some transaction allow some time, right, to be enforced.
Yeah,
you can say, 3 days waiting time or whatever, depending on the state, give you a chance to cancel or
Yeah. And you mentioned litigation, unfortunately, or fortunately, depending on your views. It's very easy for people to bring litigation.
Right. That's what I'm saying.
And I think that's what you're saying. And that's one of the reasons why we really try to help people get legal guidance on creating good policies, privacy policies, good terms of service, good contracts,
and that
and all that
to your services that you offer. I think a lot of people, just plainly, I don't understand these things.
Yeah,
Here you have a good lineup of services that you could, be helping out.
exactly.
So
So that if you are in
you're a great
litigation
source.
and you find yourself there, you have good policies, or you're formed as an
Uh-huh.
LLC or all that. Yeah,
That's,
exactly.
excellent. Thank you.
Yeah. All right, well, thank you. I don't see any other questions online. I did write in the chat, if anyone has additional questions, when you're applying for our service, well, one, you are gonna get a recording, you are gonna get the slides, you're gonna get our email addresses so people can email us with further questions.
Nice.
We'll probably direct you also to our application again. And you can write into the application your legal questions or other needs, and we can take that into consideration as we're determining whether we can assist you. But I think that is it. There's thank yous coming in the chat. I'll let Alina and Leon, if you have any kind of final thoughts you want to end us off with, but I think I just want to say thank you both. This has been very illuminating for me. We haven't done this type of program before, so we have learned a lot here, and we are very excited for the upcoming clinic, which is also with your law firm, where we will be connecting our small business owners with not necessarily you both. So if you apply, you may not be meeting with Alina or Leon, but with their colleagues or maybe them in a few weeks. But before we end, Leon and Alina, do you have any final thoughts?
No, thank you so much. We hope that you all have found this helpful, that you're leaving with some of your key questions answered or have more questions that hopefully we can answer at this upcoming clinic. But we've really enjoyed putting this together and look forward to supporting in this clinic. Thank you so much for the opportunity to be here.
Thank you so much
Thank you.
for making the effort to join everybody. It was a lot of fun.
Yeah.
Thank you.
All right. Have a great day,
Oh, I'm
everyone.
getting lots of thank yous and great information. So I'm going to end this, but
Great.
thank you all. Please be in touch, anyone online if you have further questions or needs. And thank you again, Alina and Leon. We really appreciate you.
Thank you. Bye.
Bye.